Yes, Mr. Knox, can we just give you notice that
Yes.
Without in any way prejudging the point with which we started the morning, if we were to conclude that the Court of Appeal's judgment were otherwise correct, and if we were to conclude, contrary to your submission, that the Court of Appeal should have done something about it differently from what they did, and further, I appreciate this is contrary to your submission, that it's open to us to do something about it, then I think against that event we should invite you to put forward any points which are open to you as to why, as a matter of discretion, something should not be done about it. In other words, there are, in that situation, two alternatives. One is for the court itself to consider the exercise of discretion. The other would, of course, be to remit it to first instance, if there is jurisdiction. We're not prejudging the jurisdiction because we haven't made up our mind about it, but just in case we get to that point in this complicated case, we would wish to have the material available to us.
Yes. Well, my lords, I must admit I'm not, my lords, my lady, I must admit at this point in time, I cannot say I've got all the material I would no doubt have sought to get hold of,
No.
Had we had advance notice of this point.
Yes, quite.
I don't know if in those circumstances it would be possible for us to put in written submissions in 7 days.
Of course, well, I think 7 days would be unduly short. In
this week.
It seems to me that bearing in mind the way in which the point arises and bearing in mind that this is not, on the face of it, particularly urgent, and Easter is coming, you're entitled to, you would certainly be entitled to be longer than 7 days.
Maybe 21.
21 days might be more appropriate.
Yeah.
But I do think we would be helped, and I mean, obviously it's open to you to expand the constitutional point if you say we really are tied by the issues which are issues of greatest importance. I mean, I think you probably detected some scepticism about that because it might be a rather odd fetter when we're dealing with appeals generally, but leaving aside that point, if there are points you want to make on it, they would be included.
Yes. I mean, I think our principal point would be, this is the point I made earlier, it looks like a conscious decision to pursue this particular strategy rather than the one which your lordship is.
Well,
now that may not be a complete answer, but that may be what you might call simple answer.
Well, the same applies obviously to you, Mr. Maharaj, and equally Mr. Brindle, because it seems to us, having looked a little at the rules, that the court can and should, if necessary, act of its own motion, certainly in pursuing the overriding objective, and the fact that this point occurred to all of us is one which we can't simply leave without further consideration if it arises. Maybe misguided, but you can persuade us of that.
My lords, dealing, if I may, for the moment, just with the main appeal, if I can call it that, rather than the new point, I make 4 main points. The first is this: I say that the rules are plain and require that a case management conference is fixed as a specifically scheduled event, as a case management conference, whether pursuant to Part 27 or Rule 27.3, or in one of the other ways specified in the CPR, because there are other rules which say the court will hold a CMC. But outside those specific ways which are set out in the CPR, there is no general discretion to treat a hearing as a case management conference other than in the way set out in the rules. And I say, therefore, in this case, there plainly never was a case management conference, properly so called, nor was one ever called for, pursuant to Rule 27.3, and therefore the automatic strikeout provision automatically applied. That's our first point.
So you're going to develop that?
Yes, I'll develop that, yes. I'll take you to the relevant rules which talk in terms of when the court must or can treat a hearing as a CMC.
Does it involve saying that Justice of Appeal Jamadar in his recent decision went too far?
No, it involves saying you have to read very carefully what he said.
Right. Good.
And if he really did go as far as my learned friend says, he did go too far.
Right.
Um,
Yes, right. Well, okay.
So I hedge my bets.
Point.
But I say, in context, he cannot be saying what my learned friend says. The second point is this, that there is good reason, or there are good reasons for why a CMC has to be fixed as such. That is because this is the point at which the court takes over the conduct of the case, and in particular fixes the trial date or trial window. Secondly, and relatedly, before that point, the parties have considerable freedom to change their case or add new parties, but after which they no longer have that freedom. It's much more restricted. And thirdly, there are a number of other things that are meant to happen at a case management conference, and if they don't, you might be in difficulty asking the court to do it later. For instance, cost budgeting and things like that. Thirdly, our third submission is this. So far as material, and we say it's entirely immaterial, the judge was not, in any event, quote, actively managing the case just by adjourning the dates for the hand-down of her decision. We would go so far as to say that is a misuse of the phrase actively. It's passive, if ever there was. And therefore, for that further reason, one cannot treat, so far as the matter arises at all, one cannot treat the judge's decisions to adjourn as somehow actively managing the case at a case.
So it'd be active if the judge said, I think this is a case for mediation, I'm going to adjourn it for 3 months to give you an opportunity. But it's passive if the parties say, we think this is a case for mediation, will you adjourn it for 3 months?
Well, not in this. Of course, there comes a point where what is active, what is passive. In this case, it's just the parties writing in saying, we're discussing.
Yes, but this is something which they had to put before the court to get the court to change its previous order.
Well, I'm not sure. It's previous hand-down date, yes. Yes. But in my submission, I would submit that is not what is envisaged by the phrase actively managing a case, just acceding to a party's request to adjourn. I submit it's difficult to imagine anything less active than that.
What date does it get automatically struck out?
4th of April. 4th or 5th of April 2016.
And thereafter, there was nothing left on your case?
So on our case, yes, thereafter.
No injunction, no anything?
Yes, at that point we say everything falls away.
So what were you up to?
Good question. My lords, I think it's fair to say the parties didn't realise.
No.
I mean, it's said against me by my own friend that we kept this up our back pocket. Well, of course.
But we don't have to find that. I mean, what was quite clearly the parties proceeded on the basis that the proceedings were ongoing, whereas on your case now they had disappeared.
Yes.
Isn't there some sort of estoppel?
Well, my lords, one wonders about that, but it wasn't run below, and in my submission, it's difficult to see how an estoppel can arise when you're talking about a court-driven process. In other words, that point might go to an application for relief from sanctions, but it would not, in my submission, go to the proper construction of the rules.
If you're
because the court needs to be in charge of all this.
Yeah. If you're right, Mr. Knox, this is an unusual action because what looks like an interlocutory decision is really the decision in the case. But come out of that. Let's imagine a completely straightforward action for personal injuries, debt, whatever, which duly proceeds within 9 months or a year to trial on the merits, evidence given, judgment given. And then subsequently it dawns on the losing party, it doesn't matter which, that there's never been a case management conference. If you're right, does it follow that everything falls? Well,
there will be any number of points arising on the basis the parties that continue to act on the basis, or there may be some implied dispensation.
They might not have realised.
Well, the court wouldn't have realised either.
Absolutely, but that's what happens in life, and it looks as if it happens, well, perhaps not. Anyway, it certainly happens from time to time. Supposing that everybody has simply overlooked it, does it follow from what you're saying that the judgment, the enforcement of the judgment, which might have taken place by now, anyway, the whole thing collapses?
On the face of it, yes, but that was subject to 2 points. The first would obviously be the application for relief.
Yes.
And the second would be any arguments as to whether, in fact, there had been at least an implied dispensing of a case management conference by the court.
So you can have an implied dispensation, can you?
Possibly. My lords, I say that certainly hasn't happened here, but in circumstances as extreme as that, when you can see communications have passed, as were across the line between the parties, and you can see they've all operated on a common assumption, then one would say, and the court has operated on that same assumption, then that might be a rather different case.
Does the court also have power to extend the time for the making of the application for the case management conference?
Yes.
Presumably it does.
But it likes,
Must do, mustn't it?
Yes, and it can adjourn as well.
Quite.
I think I might
So
say.
can you have an
adjourn.
implied extension of time? Why not?
My submission on the face of it, not. Well, the difficulty is that would undermine the whole automatic strikeout provision.
Yes.
So
Well, it might. But you see, if as in this case, the judge accedes to a joint application
Yes.
to delay the giving of the anticipated judgment,
Yes.
to enable parties to discuss possible accommodation, is she not, by necessary implication, extending the time for any application for a case management conference?
In my submission, no.
You say not?
No, not necessarily at all. No.
Because?
The claimant's risk. Well, the claimant might think so, but it is not necessarily the case. It doesn't follow as night follows day.
Well, she's saying, isn't she, nothing need happen while you're talking.
Well, now, my lord, supposing, first of all, she hasn't said that. She's just saying, I'm not going to hand down this particular case.
That's why I asked whether it was a necessary implication.
I submit not.
You say not. Okay.
Well, I mean, she can't have contemplated anything else happening. She's stayed present.
She may herself not be contemplating anything else. I submit that's irrelevant.
But nor are the parties. I mean, why? I know it wasn't put this way, but why haven't the parties, by their, for example, May exchange, agreeing
Yes.
to an extension, committed themselves to the proposition that the action is alive? In other words, why aren't they proceeding on a mutually agreed basis? Namely, the claim hasn't been struck out, and each of us is now precluded from asserting that it has been, because it would be very unfair if we did, because if we'd raised the point, then there would have been an immediate application.
My lords, you can guess what the first thing my answer to that is. This is an entirely new point. And I think it's certainly not the way the case proceeded below in the Court of Appeal, or indeed as I understand it, for the judge.
Yeah.
If you're going to run estoppel points, there are, of course, questions of reliance and things like that, which have to be considered.
Yeah.
It is a matter for some evidence. The court then has to weigh up whether there's been detrimental reliance, the justice of the case, and so on. Now, my lords, I can understand, you might say, well, what else could there have been to say? To which my answer is, I'm here on a second appeal, and I'm now getting this point being taken in circumstances where my client has not had the opportunity of meeting it below.
Difficulty is, Mr. Knox, that you're here, as you persuaded us this morning, in order to try and unravel the general points of importance
Yes.
which arise from these rules. It's not
Yes.
about your case, particularly, so you asserted this morning.
Well, it is about our case too. I mean,
Yes, but you see, if you want us to try and ordain how these rules are to work generally, one of the
Yes.
things that you'll need to address is implied dispensation, implied extension of time, ouster of the concept of automatic strikeout when there has been an application for an interlocutory judgment.
well, the last is a question which is before your lordships. I accept that, but the others are not. What you might call the implied agreement, stroke estoppel point. No one's going to take a time point in the meantime. Those certainly aren't. That isn't the way the case has been put against us.
I'd like you to consider it as an implied agreement or estoppel, an implied action by the judge.
Well, in my
Anyway, there we
submission,
are.
if I can deal with that now, I
Yes.
submit she has that you cannot imply that.
Right.
It is simply uncertain. She has not turned her mind to it, nor have the parties asked her to turn her mind to it.
Yeah.
It's entirely up to the claimant to file their notice when they're meant to. If they don't, then in my submission the rules follow, unless the judge herself turns her mind to it. Now, supposing the judge had made some order when she adjourned the case and said, I see, by the way, that the time has already gone by, and this case on the face of it is struck out. But on the other hand, I'm prepared, in the exercise of my discretion, to extend time. Now, then the judge could properly be said to have turned her mind to the issue when she granted the last adjournment.
But it's,
in May.
I mean, look at March the 7th, rather than May. There she is bridging the critical date.
My Lord, can I just, yes, this is
It's,
page 133, 135.
yep, exactly. Yep. She's bridging the critical...
133.
133 in the hard copy, 135 in the MS.
Maybe 541, is it the electronic?
Well, yes.
Which is it electronic?
Right hand.
It's 133, is it? Yeah.
What's the electronic one?
135. At the right-hand corner of the page, there's some smaller numbers which are
Those
sort
are
of
the-
close to the MS numbers, -2.
Yeah.
Anyway, yep.
Yeah. Well,
Yes.
at that point,
Yes.
the judge cannot have had in mind, can she? I think you accept that she can't have had in mind any possibility that the action would disappear like smoke on the beginning of April.
But she doesn't know what's happened. She won't necessarily know, for instance, that there's been no application for a case management conference, or indeed a fixing by the court of
But
some.
she's the docketed judge, so she jolly well should know. I mean, you come in front of her.
My lords, the trouble is we just don't know that.
But she's the docketed judge, isn't
Well,
she?
she was the docketed judge, I accept that.
Yeah. So she would be, on the face of it, aware of that. And,
Does that mean she deals with every procedural application?
As I understand it, that's what's meant to happen. But in any event, my lords, I submit this is just too general. It may be, my lords, what it comes to is this. By this time, this Monday, the 7th of March, the case was not automatically struck out, but it was coming up to the time when the claimant was supposed to give notice. So at this point, there'd be no reason for her to be concerned.
Well, except that she's adjourned it to the 18th of May, and by then, it certainly would be struck out.
Absolutely. But she's not saying anything about you don't have to comply with 27.3.
No, I follow the argument.
I mean, and my lords, I submit that is clear. She'd have no reason to turn her mind to 27.3 and the requirement for notice and so forth. At this point, none at all. So one cannot, in my submission, just looking at this document, read anything into the adjournment of this handout.
What is the time within which it must take place? You have to give notice of it within X days. Is it?
I think it's 14. Well, you have to. I think it's basically 42 days after the filing of the last offence.
It's,
So 28 days
28.
after the filing.
yes, it's 4 weeks and not more than, it's 9, subparagraph 9, isn't it?
Yes.
So it's,
Yes, not less than 4 weeks.
but that's timed from the defence being filed,
Yes, and then I think after
not
that.
from the request.
Forgive me, yes, then there's the request has to be filed within, forgive me, my lady, I'm just digging out the rule.
Yeah, from defence file.
But
14
it's 7.3.
days.
Something.
14 days from the last defence, isn't it? That
Yes.
you have to have given, that's the court's giving notice, and it's 28 days.
After that.
No, after, I think it's the case management conference has to take place. The court has to give notice within 14 days
Yes.
of that event,
Of the
but
last
it's
offence.
28 days. I don't know whether it's, yes.
No,
It is.
You have to give notice within 20 days, applying for a date to be fixed, and then, isn't that it? And then
It's not the clearest drafting in the world, but I think what it means, my lords, I
It's
submit,
42.
it's taken to mean it's 42 days altogether
Yes.
from the date of the filing of the defence.
Yeah,
Yeah.
but the last offence.
Yes, of
Yes.
course.
But then you count again for the timing for it, so you might end up
Yes.
in a very short time before it
Yeah.
happens,
Yes, it could do, yes.
because you're counting from the same start date. And on this set of facts, neither of the events of extending time actually complied with 9.
No,
But that may not matter because it only says shall, and I imagine you can have if you'd fixed it 9 weeks after fence, it would still be a perfectly valid case conference.
it may. My Lord, that
You'd
may
just be
right.
impliedly extending. I would
Yes.
have thought.
My Lord, I was just on the narrow point. What was the position as at March 2016?
No.
And I say at that point there was no need for the judge to be concerned. There was, so to speak, no error anyone was operating.
Yeah, but
at that point.
if she knew that when the date of defences were, I don't know whether she would know, there was 2 months or 8 weeks from there, so it was around about 20th of April.
She wouldn't necessarily know in the statement of claim. Well, it depends what she's seen of the
It's the
papers.
defence, isn't it?
It's the
Defence, yeah.
defence.
And it's the second defence, so, yeah.
Yes.
But they're both on the same day.
Yes, they are in this case.
So, all right, yes.
But you presumably say that even if a judge is a docketed judge, if all happens is she receives an application signed by both sides
Yes.
for an adjournment to discuss whether the case can be settled, she might not go back and look at the timetable of defences and so
Yes.
forth.
One wouldn't necessarily assume she's done that at all.
No.
She may have done, we just don't know. But in my submission, it would be wrong, especially as this point hasn't been run below. It would be wrong for this court to proceed on that sort of assumption. And I do urge, my lords, my lady, there is an injustice in being asked to meet new points on the second appeal, which are, to a certain extent, perhaps fact-sensitive, or at least sensitive to what those in the courts below might know better.
Well, I think we appreciate there may be an injustice.
My lords, there may be, but my lords, one cannot. There may be other answers.
Yes.
And I do respectfully submit that it would be wrong, as it were, to try to find an answer to meet the justice of this case, either by twisting the rules or by reading things into tiny communications, which in truth aren't there.
Yeah. No, well, we appreciate that.
A problem that's been troubling me is this, if a claim in support of an arbitration like this were proceeding
Yes.
in England, you'd apply under Part 8, and that wouldn't invoke pleadings, disclosure, case management conferences, or anything. You just go to, it's a bit like a fixed date hearing, you go straight to a hearing, and the court then manages the case from start to finish in accordance with the Part 8 procedure.
Yes.
As I understand it, but correct me if I'm wrong, there isn't any Part 8, as we call it, procedure in Trinidad and Tobago. Everything happens under Part 8, but there isn't the separate procedure where you don't, which bypasses, if you like, the requirement for pleadings, disclosure, case management conferences, except the fixed date procedure.
Well, exactly, which is used for things like possession proceedings or specific types of proceedings.
I couldn't find
Proceedings.
the definition of fixed date or anything that indicated when that applied, because on the face of it, a claim like this might be a good candidate.
I agree. My lords, I think it is. There is a definition. I don't think we've put it in.
Well, I've got the whole book here, if it helps, but
I remember seeing.
it strikes me very forcibly that in a case where nobody is seeking to get any final relief other than what you can get at the interim stage, because there is another proceeding on the merits going on in the arbitration, it's perfectly understandable, if you like, that neither the parties nor the judge thought much about your case management conference.
My lords, I think 8.1 subparagraph 4
8.1.
gives you a definition of, gives you a part definition of fixed date claim.
Okay.
I don't think we have it in these rules, but in essence, I can.
It's defined in the definition section.
I don't know if it is defined.
It is.
Oh,
Yes,
it is. Oh,
Yes. No, it is.
Well, it's unless there's a practice direction,
Oh, it says when it must be used.
or unless, because it's under some arbitration act that requires you to proceed by originating summons or motion, it looks a bit narrower than our Part 8, what in England is called Part 8.
Yes.
Is there an arbitration section in the Trinidad rules?
In the rules? Yeah. I'm not sure off the top of my head.
Or a practice direction?
I don't, my lord, I would have to check.
Okay.
Not that I know of, but that there may be. There's certainly an old Arbitration Act which deals with the matter. I'm not sure if any specific rules relate to it.
Well, presumably.
But
Yes.
But in my submission, there's also another answer to that, and that is the claimant did not just, perhaps I can deal with it now, did not just seek what you might call interlocutory relief, but it was seeking the setting aside of the mortgages. But it also claimed that these mortgages had been made in breach of the anti-fraud provisions in one of the Conveyancing Acts. In other words, it alleged in terms they'd been made for the purpose of assisting avoiding a judgment or dissipating assets. My Lord, can I just dig that?
Why doesn't that go with the Moreva?
Well, not necessarily. No, and far from it. They wanted a self-standing action. It's claimed as final relief.
I was going to say, what is the jurisdictional basis of the claim? It would be interesting to know if you're going to...
Well, if you go to file 1,
Yep.
I'm looking at the statement of case begins at page 89 at the foot of the page in the hard copy, or 91 in the MS. And this is the statement of case. And if you go to paragraph, I think it's paragraph 24, page 101 or 103, you'll see that a specific cause of action is pleaded in relation to these.
Under the Conveyancing Act.
Under the Conveyancing Act, which presumably, I haven't checked it, presumably similar to our Insolvency Act.
No.
And then you'll see the facts that are alleged in support of this. And then quite a number of facts are alleged until you get to in relation to each of the respective mortgages or debenture. And then,
none of that could be dealt with without a trial. Unless
Sorry?
there was subject to summary judgment, that would need a trial.
That's a trial. You would need a trial, yes. On page 109 or 111 in the MS, you can see another allegation is made about these against both defendants.
Yeah.
Para 25, these are sham transactions. Court has jurisdiction to set them aside, and they rely on previous matters. And then you get to the relief at the end, page 111 or 113 in the MS.
Declarations.
They want declarations. And so this is not just a case. Oh, well, yes, declarations and order over the page 112 or 114. Declarations for setting aside, expunging, so on and so forth. Quite a lot of relief.
Well, yes, and I understand why you say that would need a trial, but didn't it receive it? I mean, the judge on the 10th in her reasons given on the 10th of June at page 344 of the hard copy of the same bundle.
Yes.
I'm afraid I haven't worked out how the electronics work, but anyway, paragraph 68 of that judgment found that the transactions were shams.
She shouldn't have done. This is an interlocutory application. As one of our complaints. I should say there was another set of appeals, as I understand it. We're saying, what on earth do you think you're doing, making final findings of fact when you've heard no oral evidence?
Well, just give me a moment to catch up with that. I didn't know that, but fair enough. And has that appeal been heard?
No, as I understand it, not.
So the finding stands, but you dispute it.
So,
Well, or we say she couldn't, well, not only...
what was she
dispute,
determining on an interlocutory basis then?
Well, all she could have
real
determined
risk of
on the
dissipation.
basis was essentially the granting of the injunction or not. And indeed any restraining orders in relation to movement about of these mortgages.
Well, the paragraph immediately following the ones about the mortgages says, I therefore come to the conclusion there's a real risk of dissipation.
Yes.
So
Yes.
if one reads it as a whole, it may be that she's really looking at what undoubtedly was an interlocutory question.
Yes. Well, we would accept she was certainly entitled to do that.
Yes.
But we do say there was an underlying substance to this matter. Certainly, and my lords, certainly as things stood before the judge gives her judgment, there is obviously an underlying substance which goes beyond the mere interlocutory application she was hearing at the time in January. And indeed, one of the paradoxes of this case is both the defendants were quite happy for the mortgages to be revested, so to speak, in my client. And the claimant was objecting to the very fact that that then happened. Anyway, so because that is what happened after the strikeout date.
But that's a matter which only affected RL, the mortgages, isn't it? As against SIS, the interlocutory proceedings were effectively all there ever was. There was a freezing order which embraced all their assets.
Well, that's true, but the claim for declaration was being made against my clients as well. The idea being that my clients had wrongfully transferred the benefit of the securities to Rainforest.
Yeah.
And there was specific calls of actions being relied on, saying that was wrong in one sense, in any event. But I mean, what could strictly have happened is the judge could have said it's inappropriate to grant a freezing order because, let's say, I'm not satisfied by the undertakings. All sorts of reasons. It was going to be for far too long. But on the other hand, I'm going to set those transactions aside under Section 78 of the Convention.
They didn't need to do that to grant a freezing order binding the mortgages, even if they were registered in RFRL's names. You could join to a freezing order a third party if there's a prima facie case that they're just holding it for the owner of the assets.
It may well have been unnecessary, but that's what the claimants thought. The claimant was asking for more than just a freezing order against both of us. And theoretically, it could have got no freezing order against us, but nonetheless, at trial at the end of the day, an order setting aside the relevant conveyances or securities. So there was some substance. And, my lords, I do respectfully submit one has to look at the matter as things stood before the judge gives judgment rather than afterwards. As things stood before then, it was possible she'd turn down the application for an injunction, but say, I'm going to give directions for the hearing of the setting aside of these conveyances. My lords, I got to my third point, was the opening. Can I just mention the fourth point I wanted to make? And it's the obvious point, namely, the appellant's remedy, at least in the judgment of the Court of Appeal, was to apply for relief from sanctions. But it just didn't seek to uphold the judgment on that basis, or relief from sanctions basis in the Court of Appeal, or indeed here. And instead, it's chosen to go down a different route of asking the First Instance Court to reconsider the matter as a fresh application at some later date. And I submit that's really, had that happened in this case, and had the appeal been made on that basis or responded to on that basis, it may well we wouldn't be here. But for whatever reason, the appellant played differently. My lords, can I just deal now with my first point? What is the proper construction of 27.3? And does it apply on the facts of this case? And I say manifestly it did. Can I just go to the rules? 27.1. The Appeal Authorities Bundle, page 1736 MS. And 27, can I take you to 27.1 first?
Sorry, what was the page again? Authorities?
1736. 27.1, this part deals with the procedures by which the court will manage cases. I just emphasise will there. And then 27.31, the general rule, which you were taken to earlier, is the court office shall fix case management conference immediately on filing of a defence to the claim on the fixed date claim form. Then you have the provision for timing. 27.3.3, if the court does not dispense with case management conference or give notice within relevant times, the claimant shall, I emphasise shall, within 28 days of the relevant period. And in my submission, the contrast between general rule is a point already made by your lordships. There is a contrast. The contrast with the general rule is what happens under subpara 3. If the general rule doesn't apply, then the claimant has to apply for the case management conference. And you can't get any more than that out of the phrase general rule. As my learned friend seeks to say, general rule sort of somehow can mean generally. General rule doesn't, in other words, carry over into subpara 3. And subparagraph 4, if the claimant does not so apply, the claim shall be automatically struck out. It couldn't be clearer. My lords, my lady, you'll have noted from our cases the word automatically was added in 2011. And if you want to see, for what it's worth, how the formal rule looked like, you can go to page 1742, which sets out the formal rule. And in essence, apart from making one or two drafting alterations to cover the point where more than one defence is filed, automatically is really the only addition of substance. And then you...
Sorry, where is the rule in its original form?
At 1742, at the foot of the page.
Well, 74, is that the electronic page? Oh, I've got it, yes, I see it.
And it carries on over to 1743.
Yes.
The numbering's been tinkered with, but broadly...
Shall be.
It's automatically is the only real alteration.
Yes.
And then going on a little, you'll see 27.5 has the provision for relief from sanctions, 3 months from the date of the service of defence. That's why I say it's 22nd of May, is when they should have applied for relief, but they didn't. 27.6, a much softer test for applying for relief from sanctions. The only question is, has the defendant suffered prejudice? And the answer inevitably is, by implication, if he hasn't, then relief is granted just like that. A provision for what happens if relief is granted. Subpara 9, when the case management conference is to take place. And in my submission, it's important to note here, it says the case management conference. My learned friend floated, I'll come back to this later, my learned friend floated the notion that there can be a first case management conference and a case management conference which takes place before the first case management conference. I submit when one reads these rules, in particular this type of rule, subpara 9, it's difficult to read that or to get that out of it. And then subpara 10, you can apply to fixed case management conference at a time earlier than provided above. You must state why, but importantly, 12, 13 and 14, I submit, are important. The court will fix case management conference on application if it's satisfied. It will enable the case to be dealt with justly. The court office shall give all parties not less than 14 days' notice of the case management conference, and sometimes it can shorten it. Now, the reason I emphasise that is notice is important, and is obvious for the reasons already adumbrated. You need to know that the hearing coming up is a case management conference rather than some other type of hearing, and that's because the case management after the case management conference you are limited in what you can do, but also there are all sorts of things that are meant to take place at the case management conference which don't have to take place at other types of hearing.
What was there a reason why 12 has got has got the rider at the end in it? Because the earlier rules appear to say that you've jolly well got to do it.
As I understand, 12 is going with 11. I might be wrong about that. In other words, 11 says you can make your application for an earlier case management conference without notice.
It goes with 10 and 11, I see. Yes, maybe.
And my lords, that's the only way I can make sense of it. In other words, you can have an earlier case management conference if it's necessary for justice. Otherwise, you have it at the times set out.
If you add together the longest time for a party to make application under sub-rule 3, to the time from the expiration of the filing of the last offence, that's the 42 days, I think, yes, we were given, and a 14-day period for notice once it reaches the court and the court finds a gap in the diary.
Yes.
And the court's then got to fix it not later than 8 weeks from the service of the last defence.
Yes.
Jolly tight. I mean, it leaves about a day, doesn't it?
Yes. Well, a week.
But I'm not sure.
Yes, maybe, yes.
The court.
Well, 9 says that it's actually got to take place.
Yes, what I mean.
8 weeks.
I mean that. Yeah.
From the last defence.
So in fact,
So you can't add anything else in.
the court would have to fix it and give notice on the very last day on which a party would be under an obligation to apply for it.
Yes. Well, by laws, it may be tight, but one can see and it may give rise to practical difficulties in real life. It may be that it's observed in the breach, not otherwise. But the important point is this case management conference is to take place relatively early on in the case. That doesn't have to take place at the interlocutory stage, but it takes place quickly after the service of the defence. And then, just going over the page, what actually happens at a case management conference. 27.51, if you're represented by an attorney, the attorney who has conduct of the case, this is 1739, must be fully authorised to negotiate, competent to deal with the case. So there's an implication there that parties are supposed to try to talk to each other, if they can. And then subparagraph 4, if the case management conference and so forth is not attended by an attorney, the court may adjourn the case management conference or pre-trial review to a fixed date and may exercise any of its powers under Part 26 or 66. Part 66 is the costs provisions. And then the orders that must be made at the case management conference are 27.6. And you have 27.61, disclosure of witness statements and so on. But the really important point is 27.64, page 1739. The court must in any event fix the trial date or the period within which the trials take place, and the date on which it is.
I noticed in my research of the definition section, which you haven't produced, that wherever the word must appears in these rules, one should substitute the word shall.
Yes, I hadn't noticed that, Michael.
Presumably that is because shall is usually or often merely directory and not mandatory and preclusionary of anything else. I mean, what else is the significance of the change? We can look it up. I think Lady Black had her copy of the rules open, but I think that's the case in the definition section.
Have a look.
Well, in my submission, shall is still shall. Not may. It's not may.
Reminds me of a copy of the Law and Practice of Insurance in Biafra, which I once had, where the foreword said, wherever the word Nigeria appears in this volume, substitute the word Biafra.
Well, that may have made more sense, but but my lords, just going to 27.64. What has to happen at the case management conference is the trial date must be fixed. And in my submission, that's why you have all these restrictions on amendments and joining new parties afterwards. It's all of a piece. You fix the trial date, everything's fixed from now on. If you're going to change that and you've got the trial date fixed, you're going to have some pretty good reasons. And if you just go on to 27.8, you can adjourn a case management conference, but only to another specific date, 27.8. And 27.85 requires you to go back to the same judge on an adjourned case management. And then 27.9, variation of case management timetable. When you get to 27.91 and read it together with 4 and 5, the upshot is that you simply cannot vary a fixed date or a trial window. Unless one reads the very end of 5 as giving the court some general discretion.
Well, yes, it clearly does, doesn't it?
Unless the court directs otherwise. But certainly, as with the structure of it is that once a trial window, a trial date's been fixed,
Parties can't
do it.
Can't agree
Yes.
to lose the date.
Yes, exactly. And only the court can overrule that. My lords, there are other rules which specifically provide for case management conferences to take place, and I submit these are important. The first is at Rule 9.7, which deals with jurisdiction challenges. Page 1698. 9.71 provides for the jurisdiction challenge. 9.76 provides for the court to make an order that it has no jurisdiction. And then 9.77 provides for the reverse, namely, if on an application under this rule the court does not make a declaration, i.e. as to lack of jurisdiction, it A, must make an order as to the period for filing a defence, and B, may treat the hearing of the application as a case management conference. And you'll note there that's discretionary, and my lords, one can see why that's the case and why that would fit into the timetable, because of course the defendant who wants to challenge jurisdiction has to enter a notice of appearance. That's 9.7 subpara 2, and that's meant to be done, I think, in 14 days. But then in real life there'll normally be quite a time by the time of the hearing of the challenge to jurisdiction. There'll be evidence, no doubt, or very often on either side. The statement of claim will normally have been served, and it may be perfectly apparent from the issues raised by the challenging defendant what his defence is. For instance, if he's challenging on forum no convenience grounds, he says, my defence on this will be X, but it's be absurd to hear it in Trinidad rather than, say, in Jamaica or whatever. So one can well understand why the court may treat the hearing of or the return date of the jurisdiction challenge as a case management conference. And that makes sense. 13.6 is another...
But what do you get out of that, Mr. Knox?
What I get out of that is the contrast I'll be coming to with interim applications. In other words, there are specific events set out in the rules which are stated to be either must be or may be case management conferences, as opposed to other types of hearing where there is no general jurisdiction in the court, so to speak, to say, oh, we're all here, let's have a case management conference. So 9.7, the next is 13.6, which is setting aside a defence. Second, default judgment, forgive me. 1707. 13.61. When judgment is set aside under this part, the court must treat the hearing as a case management conference, unless it is not possible to deal with the matter justly at that time.
It's a hearing of what? It's a hearing of setting aside or varying, yeah.
Yes. So you succeed in setting aside the judgment. The court must treat it as a case management conference unless it can't be dealt with justly.
The rule which I was referring to is 2.44, which simply states, in these rules, the word must, wherever this word occurs, shall be deemed to have been substituted by the word shall.
My lords, we have my submission. It is not intended to give some sort of mere directory quality, where you see the word must. An astonishing way of drafting. I submit must is... Shall and must are interchangeable in any event. You shall do this by tomorrow.
Why change it?
Well, why change it? Right. Anyway.
Well,
It may have a bearing on the consequences of not doing it, mayn't it? That's the usual distinction between a directory and a mandatory.
yes. Although, my lords, we are enjoined that these days to forget that distinction.
In this jurisdiction, yes.
At least as a method of trying to work out what the intention of the legislature was.
Right.
13.6 is another specific event which can be treated as a case management conference. The next, 14.6, at page 1708, this is what happens if the defendant omits part of a claim. That begins at 14.61. The bit that deals with the position if some of the claim is disputed, over the page 1709, if the claimant files notice under paragraph 2 that he wishes the claim to continue, i.e. because he wants more than admitted, the court office must fix a date, time and place for a case management conference. So it doesn't take place on that event, but there's a specific requirement for the court at that point to set a date, time and place for a case management conference.
Yes.
And then 15.6 at page 1711, this is summary judgment. What happens when the summary judgment application is unsuccessful? Page 1711. The court may give summary judgment and so forth. 2, where the proceedings are not brought to an end, the court must also treat the hearing as a case management conference. So there you have not just a discretion, but an order that you must do so. And then 74.27, you have admiralty claims dealt with, page 1794. Slightly different procedures apply to admiralty claims, but in all material respects the same as far as case management conferences.
Where is this?
Page 1794. 74.27. Case management conference. So,
Oh, I see, in that sense,
these
yes.
parts
I
are
see,
made,
yes.
the parts 25 to 27
Yeah.
are made to apply to admiralty claims, subject to certain
Yeah.
alterations.
You mentioned cost budgeting earlier on, something
Yes.
that could take place. I think it's now, is that 67?
Yes. That isn't 67. I was going to come to that on another point, but cost,
Okay.
it is at 67. Well, I can deal with it now, my lords.
It's 67.82, isn't it?
1770. You don't have, there's no provision that you have to have cost
No.
budgets in Trinidad, but you can apply for that in
Yeah.
cost budgets. And you have here at 67.8 the relevant procedure requiring a cost budget application to be made before the first case management conference. And then quite a detailed method over the page 1771 as to how you're meant to apply for a cost budget. You'll see 1771, really quite a lot of, as well, hoops have to be gone through by the lawyers. And also 67.9, you've got to have things signed by the client saying, I'm happy with all this. I presume to stop both lawyers putting in high budgets. But all this happens if you're going to ask for case management, if you're going to ask for cost budgeting, you do it at the case management conference, first case management conference. My lords, I just wanted to contrast the position we've seen in the rules I've just taken you to with 17.7, which is the interim applications.
17.
17.
Yes,
If
fine.
I can go to 17.1,
Yeah.
go to page 1712, my lords, if I may ask you. Interim remedies. And this is, in a sense, is the territory which was relevant to our claim.
Yes.
You'll see standard provisions on page 1712 and 17.1. And then when you go to the end, 1717, rule 17.7. On hearing any application under this part, the court may exercise any of its case management powers under 26 and 27. Now, in my submission, that is not saying you can treat this as a case management conference. What you can do is exercise your case management powers. Now, of course, they are very wide. When you turn to 26 and 27, 26 is 1730. I'll come, if I may, to 26 in a moment, but it's got all the usual case management powers. And then 27 is the position we're in. Now, what I submit can happen at an interim application in relation to fixing a case management conference is what you see specifically set out in 27.3. In particular, which is 1737, in particular, subparas 10 down to 14 on page 1738. So the court could say, right, should we just get on with this? Let's have a case management conference in a couple of days' time, or whatever. Or it could say, right now, it could, as long as it's just to do so. Because, of course, it won't necessarily be just to do so at, let's say, a freezing order application, because the defendant might say, well, I haven't got my act together yet. I shouldn't be debarred from changing my defence. I've hardly got my defence in yet. But there is, in other words, so I submit the scheme, and it all makes sense. The scheme of the provisions is you can apply for a case management conference at an interim application, but you then got to go through the hoops, which are set out in 27, in particular, 27.3.10 to 14, and that fits. In my submission, those specific, I called them hoops, or those specific rules in 27.3.10 to 14 outweigh or take precedence over the rather more generalised powers you see in 26. My learned friend, I think, refers in his case, and I think this morning briefly, to the powers in 26.1, which include, for instance, 26.1d, the power to extend or shorten time for compliance, adjourn or bring forward a hearing date, and then over the page 1731w, take any other step. So there's no doubt there are very general case management powers set out in 26.1. But in my submission on an application of an interim injunction, the court can't just go straight to 26 and say, I'm going to exercise these powers and treat this automatically as a case management conference. It's got to go through the specific procedures in 27.3.10 to 14.
But I suppose in the real world, if those hoops had not been jumped through, but it was a good occasion to deal with all relevant matters and the parties all had their authorised representatives present, the court could just dispense with the CMC.
Oh, it could, yes. Or could dispense with the case management conference and say, yes, we don't need to. But in my submission, that's the scheme of it. And so, on the facts of this case, in January, when the application was heard, it would undoubtedly have been open to one of the parties to ask the court to exercise its case management powers, but it would have to be satisfied to be appropriate to do so in accordance with 27.3.10 to 14. And that obviously didn't happen. So I submit here, 27.3 was still in place as at the 4th of April 2016, after the parties had served their defence.
So what you say? You say that if under 17.7 the matter came in front of a court,
yes,
and it exercised powers under 26.1,
yes,
and also gave directions for early trial of the claim, fixing the trial date, the action would still be automatically struck out unless it went through the hoop of fixing a case management conference at some subsequent date, or converting this into a case management conference under 27.3.10 to 14. Is that right?
Strictly speaking, yes. But of course, you wouldn't. No one would have a defence. Well, but you wouldn't have a defence to an application for relief from sanctions. Strictly speaking, because the reason it's important, because I haven't come to this point yet, but the reason it's important is until you know a case management conference, there is a case management conference that is to take place, you don't know whether or not you can change your defence or not, just like that, or bring in new parties. So
you do it. Well, we'll come to Justice of Appeal Jamadar, but he seemed to be saying that a hearing at which case management powers were exercised counted not as the first case management conference, but as a case management conference. You must be saying that's wrong?
If only in part, and as a matter of common sense, I think, with the qualifications he added. And my Lord's quite right
No,
too,
but
if I may.
Well, he
Well-
didn't mean not as law. He meant as common sense and as a matter of law, didn't he?
He said, if only in part as well. And my Lords, I will say, we'll come to his judgment in a moment, because it's important. Because I submit, strictly speaking, a party needs to know that a hearing he is attending is a case management conference. And the court has to let him know that before he turns up, or at least when he turns up. Because otherwise, it is possible, the predictability, which is obviously an essential part of the rules as to when you can change your defence or bring in new parties, goes. And it's perfectly possible both parties might not want a hearing at which case management directions are given to be a case management conference. Now, my Lords, but one can see, it depends on the nature of the directions given. Supposing, at, let's say, an interim hearing, the court actually directs the hearing of a trial,
Yes.
you might say in those circumstances it is clear that by common consent, you might, I'm just positing as a possibility.
Certainly by consent, it might be my main force.
Well, but it may be so obvious in those circumstances that the court has treated a hearing as a case management conference that the court, any later court would say, well, the court, that was obviously treated by the court and by all parties as a case management conference because the trial date was fixed. Take the other case where, for instance, there's just an interlocutory hearing, no trial date is fixed, but just a direction for disclosure of documents. Come back later. Now, that's undoubtedly a case management direction, but in my submission, one would not say that is a case management conference within the meaning of the rules, unless it had been specified as such.
So the consequence, if that's right, is that the judge can effectively force a case management conference into the aftermath of an interim remedy hearing.
As long as it's not unjust to the parties to do so. Well, the defendant might turn up.
It might be appealable, but
yes, exactly.
as a matter of the rules,
yes.
She can do it.
Yes.
She can do it under 27.3.14.
Yes.
Well,
she could purport to do it under 27.3.13, because it's urgent, let's say.
No, I'm looking for the one which says she can do it of her own motion. It's there somewhere, isn't it?
Yes, it's...
12, is it sub 12, picking up on 11?
No, actually, it's not there.
No, she can do it on application.
14?
Yes, 27.3.
Oh, yes, urgent
14.
cases, 14.
Yeah, if
Yes,
the parties agree or in
urgent
urgent cases.
Yes, with or without application. So she can do that.
Well, that's shorter notice.
That's just shorter
That's
notice.
just shorter
Yes.
notice.
Ah,
I'm not sure that the court can fix a case, a CMC, on application.
Yes.
But then it says, and it can make an order for shorter notice in urgent cases. I'm not sure it can fix one of its own motion, can it?
Well, that's bizarre, because it starts off that the court office shall fix a case management conference.
Yeah, but
Unless
this
the
is the
court
judge, of
officers,
course.
including judge as well.
Yes, but
or
this is-
judge directing the
You
court
lose
office
the
too.
time. The time goes by, does it?
but this is the judge on the interim merits hearing.
Yes.
Does it follow from what you're now saying, and you may be right, I don't know, that she can't fix the trial date? Because if she does, she's depriving the parties of the ability to amend and add additional parties, and they haven't come, you would say,
Yeah.
prepared for that.
Exactly.
Is that really right?
Yes, that is exactly my point. She can exercise the powers you see in 27.3.10 to 14. Query what shorter notice means. Could it mean, right, I'm
Might
giving
mean
2 minutes
tomorrow.
notice, come back in 2 minutes. But maybe, it may be so urgent. One can imagine that. We can have a trial of this case next Monday.
Well, it could mean that, but it's much more likely that it will be a case of no immediate urgency in the trial date, but it's a jolly good opportunity now to fix it. And you might canvass the parties, and you might say, well, look, come on, we can do this in 4 months' time. But you say you can't do that.
Strictly speaking, no, under these rules you cannot do it, unless all parties consent. It may be that in those circumstances it will be taken that a case management conference has taken place because all parties consent and all the things that have been done have been. I mean, it might be said, well,
You'd have to take it as a dispensation,
a
wouldn't you?
dispensation, yes. I will dispense with.
And in particular, preparing an application for cost budgeting might be quite a complicated process.
Well, absolutely, yes.
Yes.
Such that unless you had time, the judge would suddenly saying halfway through an interim hearing, by the way, tomorrow I'm going to do a CMC when I give judgment. Party could get up and say, well, hold on a minute, I had always planned to ask for cost budgeting in this case, and I won't have time to get my budget together in time.
Well, absolutely. It's certainly be entitled to say that. I mean, it's a question of what a judge can do rather than what a judge should properly do. A judge, in my submission, would not properly say, at an interim application hearing, when she hands down judgment, say, if she hands it down quickly, would not say, right, I'm now going to treat this as a case management conference. She might give directions, that's very different, but she could not say, I am now treating this as a case management conference without the parties' consent. And the parties, I submit, probably could consent under 27.3.14a, because she'd be given short notice. But otherwise, the defendant might say, I want more time to consider my position.
But you don't only have one case management conference in the course of a case, do you?
No. No, you can have more than one. That's certainly the case, yes. I mean, obviously, you only need to have, for the purpose of 27.3, it's only talking about, in my submission, the first.
That is the case management conference.
Yes. Clearly. And once you've had, as it were, the first, then obviously you don't have to have any more notices for the second, third, and fourth, if there are to be such. If I can, my lords, my lady, you will have picked this up from our respective cases, but there are a number of particular points which are obvious disadvantages of having a case management conference early if you're not ready. And the first is at page 1702.
I find all this very puzzling because you're supposed to be ready under the scheme of 27.3 from the very beginning of the litigation. 27.3 postulates that normally the court will fix a case management conference immediately after the filing of a defence. I suppose that's a certain trigger, a certain indication of readiness, but and if that doesn't happen, the parties have to apply for one, or the claimants have to apply for one.
Yes.
So there's no suggestion that the parties' convenience
I agree.
is really dominant.
Well, obviously, after that point, it certainly isn't dominant.
No, I see.
Subject, of course, to the right to apply for an adjournment of the case management conference in appropriate cases. But before that point, their convenience is important. And in particular, in a case like this.
Well, the parties get a minimum of 4 weeks, don't they, from the service of the last defence to prepare for a CMC.
Yes.
That's 27.3.9, because it mustn't take place less than 4 weeks after the defence is in, subject, of course, to the court's power to abridge it. But that would have to be exercised justly.
They only get a maximum of 8 weeks.
Yeah.
That's right. And the idea is things take place quickly after you've served your defence. And you can change or amend your statement of claim, or you can amend your defence up until the case management conference. You don't have to trouble about permission or anything. After that, you're in the rules. But going back to the interim applications, I submit that it would have been very difficult for the judge in this case to treat the hearing on the 8th or 10th of January as a case management conference.
You probably ought to put before us, just jumping around, you probably ought to put before us the application which was made and the evidence which you say supported it for under 27.3, an application for relief.
Yes, unfortunately it's not in the papers.
It's not in the papers, no.
No.
Yeah, well, actually 27.38 says you have to have...
There is a reference to it in one of the letters.
Yeah. Yes, well, I mean, just
we don't have the application itself in the papers.
We probably ought to see it.
Well, we can make a note of that. My Lords, can I just go to the consequences?
Yes.
If you go to page 1702, I mean, the first consequence is you can't, after the case management conference, so-called, you can't amend your case or bring in new parties without satisfying certain conditions, and sometimes stringent ones. The one is 10.6, 2 and 3, 10.6, 1 to 3, at page 1702. So you can,
It's pretty stentorian, isn't it? 10.6.3.
yes,
Not enough that it doesn't do anybody any damage.
it's difficult. It's difficult to get. It's difficult to bring in a new part of your defence. Now that ties in with other provisions. But if I can just go sequentially for the moment through these pages, 10.10.2, 1703. Restrictions on service and reply.
Have these rules led to a significant increase in claims against lawyers?
Don't know, my lords.
Right answer.
But again, you've got to, the case management conference is when you ask for permission for reply.
Well, you
So
can
you've got to know-
always ask for another one, can't you?
You can, yes, because this doesn't say first case management conference. 18.4, page 1718. A defendant may make an ancillary claim without the court's permission if the ancillary claim is issued before the date of the first case management conference. Where we haven't done so, the ancillary claim may only be made if the court gives permission. And then you have restrictions on how that permission is granted in sub-rules 3 to 5. And an ancillary claim is defined in 18.11 as a claim against anyone other than the claimant.
So you can't, does it follow?
Sorry, it's a claim bringing in a new party, essentially.
And that's a defendant, isn't it?
Yes, so the defendant will bring it. Essentially, 18.4 is applying to, let's say, third-party claims or counterclaims against new.
Yeah, but it means if you've forgotten one, that's not good enough because it won't be based on a change of circumstances.
Yes, exactly. And then 18.5 is counterclaims. In other words, if you want to bring a counterclaim against the existing claimant, you have similar types of restrictions from 18.5, 1 to 6.
Good explanation.
18.45 is about as tough as I...
Tough. These are tough. And that's exactly why we say you really have to know that you're turning up to a case management conference rather than some other type of hearing. Because otherwise you'll think, well, I've got plenty of time. You know, I'm still wondering about joining in Z.
Well, it's not even that, is it? I mean, it might just be reframing your claim, for example, as between contract and tort against a third party.
Yes.
Even though the reality is much the same.
My Lords, there is an authority that says, as far as amendments are concerned, if they're what you might call trifling amendments, the rule doesn't apply. There's a Privy Council case to that effect. But anything of substance, you are going to need to get yourself within these rather tight restrictions to get through.
What's the Privy Council?
Well, yes, what's
There's Siebelac,
That's that.
which is a decision, I think, of Sir John Dyson, which you can find at tab 6, MS 1837, where he basically adopts, where he said he refers to the reason for these rules. Where he says you shouldn't. If you go to page 1843, I think. Paragraph 24. I think this may in fact be a predecessor, but it doesn't matter for present purposes. Para 21.3 is plain, refers to a change in the statement of case, not a change in the nature of the case being advanced. It directs attention to the text of the statement of case. On the literal reading of the rule, any change to the text, however minor, is caught by it. Then he goes on to say it's obviously not intended to mean that.
So that in that case, you could add the lost year's claim and the claim for funeral expenses to your personal injuries action.
Well, I think you couldn't actually. I think that
You couldn't.
You couldn't. No,
He rejected in the previous paragraph.
Is a change.
Yeah.
An alteration in the tenor and character, or a fundamental change, was
getting
not what it was limited to.
Just getting a date right or something of that kind.
Yeah. Well, for instance, the date right,
Yeah.
or maybe adding or you're liable in tort as well. I mean, something which is not going to change in any material respect the case.
Well, it
Facts
might
that have to be
change.
investigated. Sorry?
Presumably you're changing the limitations. So that's the usual reason.
Well, in that case, yes, assume you're not doing that.
It seems to me that the CBIL Act doesn't amount to much of a relaxation.
No, it's quite tough. And of course, the context, you'll see paragraphs 21 to 23 is the board has taken a tough approach precisely because of the need to change what is called the litigating, the easygoing litigation culture that had previously prevailed. And paragraph 28 will get the same point. And indeed 30.
Yeah.
And then, if I can just go back to the rules, as well, what you might call the toughness of the consequence of not doing things by the Case Management Conference. Rule 19.2, this is adding parties. I'll make submissions, some other submissions on this later, but it's page 1725 to 1726. Especially sub-rules 6 and 7 of 19.2. Court may add or substitute a party at a case management conference, but not afterwards.
And the same very tough condition.
Yes, and very loose regime, so to speak, beforehand, 19.2 sub-para 2. So in other words, you can do what you like beforehand. But afterwards, you're in trouble.
Well, it omits the word significant, which appeared in the context of ancillary claims and so on.
Yes. I'll come back, if I may, just for a moment to the comparison between these in relation to my learned friend's submissions about first case management conference. And then finally, 20.1, which is amendments. At page 1728. 20.11, you have the freedom to do what you like before the case management conference. But then you get progressively tougher regime depending on whether you ask at the case management conference or afterwards. 2, 3, 3A onwards.
Right.
So that's one set of consequences of a hearing being a case management conference. There's another set of consequences. The first is the point I took you to earlier, Rule 27.51, which the parties are evidently expected to be able to negotiate with full authority. That's why the lawyers have got to turn up with full authority to negotiate at that hearing, rather than at another hearing. They might say, well, I'm only here to deal with the hand-down of the judgment, or I'm here to deal with disclosure, but I've got nothing else to say. Second, in relation to disclosure, page 1746. Rule 28.5, sub-para 3, you have, as it were, an automatic right to make an application for specific disclosure without notice at a case management conference. You can't do that elsewhere, obviously.
Sorry, which was this? Where was it?
28.5 sub-para 3.
Yeah.
So you better go armed, as it were, if you're trying to cut down disclosure with your arguments for saying we resist this application. Or on the other hand, the court, I mean, one imagines what this is to deal with is if the judge says, well, I think there's certain issues which haven't been properly covered here. Don't we need to get this document here and this, that and the other? I don't know, but a case management conference has a particular consequence in relation to disclosure. Likewise, experts and referees, you're supposed to deal with them, perhaps not so contentiously, at a case management conference. 1754, Rule 33.5. Provides for just a general rule for expert evidence to be provided for at a case management conference. And you have a similar scheme for referees at page 1760, Rule 41.3. You have the cost budgeting point, which I went to earlier, 67.61 and 67.8. That's, you have to apply for a cost budget at the first case management conference.
Sorry, you have to do it then, do you?
Yes, going back, I think it's 67.8.
Yeah.
1770.
Must be made at or before.
Yes, at or, forgive me, at or before. But again, that's your deadline.
And the application has to have an awful lot of stuff attached to it.
Yes. Yeah. And the client has to know what's going on and all sorts of things. It's quite complicated. It's quite a lot of work, if I can put it this way, has to go into it. And 68.7, you go to Rule 68.7 is another thing that happens at a case management conference. This, I think, is to do with summary proceedings for possession of land. This begins at 1791. And this, I apprehend, is in fact what happens under the fixed date procedure. So strictly speaking, it's not applicable to this claim. But you'll see at 68.7, you seem to have a provision which mirrors the sort of summary judgment provision. If you don't give judgment for possession, you deal with the matter as if it were a case management conference.
Yeah.
Presumably that has to be treated as a case management.
While you're on that subject, if you're coming to it, Mr. Knox, please just do it when you
Yes.
are. But do the rules otherwise deal with the interrelationship, if any, between an application for summary judgment and the case management conference?
No, I think I've taken you to the one. I think I took you to the summary judgment summary judgment rule.
You took us to the setting aside default judgment.
And also, I think also summary judgment.
Is it? Thank you. No, I'm sure you're right.
It's 50. I think it's 15. Rule 15.
Yes.
And that's why I said you just have to give case management directions.
It's 1711.
And one can perhaps imagine why there's a difference between that and the setting aside default judgment. Because you might set aside default judgment because it's been wrongly entered in the first place, and the defence hasn't necessarily been served. Whereas with summary judgment application, you will always certainly have set out what your defence is.
Right.
So presumably, if judgment isn't given, the court must give directions as if the hearing were a case management conference. It gives directions, but no one issues a case management conference and summons, so the matter is automatically struck out.
But this is a fixed date procedure, so it doesn't apply. The possession proceeding, I was just taking you to that, but this is in relation, possession proceedings are, I think, what I'm saying is that what you have to use the fixed date claim.
Yeah.
But you have, I'm simply making a rather broader point, what the way the rules operate is they say in terms what types of hearing can be case management conferences or must be case management conferences. Per contra, that doesn't apply to interim application hearings. My Lords, can I take it to the authority of the estate management case, Mr. Justice of Appeal Jawadar's decision?
It's supposed, just to put, I'm sorry, I'm still on 15.6.
Yes.
What would happen if the court didn't do that? If it didn't utter the magic words, and this is now a case management conference, isn't it?
Well, it may not matter if it doesn't utter those words, because if it does give, supposing it doesn't give any directions at all, well then it might be said the court hasn't done what it should have done.
Yes.
And therefore there's been no case management conference.
Therefore the case might be struck out?
And presumably you would get back into the system on the basis there has been no case management conference at all.
And therefore it might be automatically struck out?
Yes, I'd imagine, my lords.
Subject, of course, to your answer that, as in every other case, there'd be an opportunity for an application for relief. But subject to that.
My lords, I have to admit, I hadn't considered that point, whether 27.3 would kick in those circumstances, because, of course...
Yes, quite well.
One doesn't quite know what would have happened, which would happen to issue an application for summary judgment after the filing of a defence. But you may have done so without the filing of a defence.
Yeah.
If a defence hasn't been... Suppose, for the sake of argument, the defence hasn't been filed. If the court says this claim's obviously there's obviously a decent defence to this, and then the court gives no directions, wrongly gives no directions, then on the face of it you'd be back in 27.3.
Yeah.
Would you?
Whereas if you had filed a defence, and then the court says application for summary judgment dismissed.
So what would happen if you had a heavily adjourned summary judgment application,
Yes.
but a defence filed right at the outset? Indeed, sometimes summary judgment's even sought after defence, but let's suppose it was filed a week after the summary judgment application.
Yes.
Everybody knew that if this was going to a contested summary judgment hearing, then the court must do a CMC at the end of it.
Yes.
Because, as I read it, the summary judgment rule it's mandatory.
Yes. Yes.
So everybody's assuming that there is going to be a case management conference at the contested end, if there is a contested end of the summary judgment process. Does that let them off does that let the claimant off having to apply for a CMC 14 days after the defence comes in? When you may be still a month before the summary judgment hearing on the evidence, because the parties are still completing their evidence and the court's still trying to find you a day or two or three, depending on how long the hearing takes.
Yes. Well, on the face of it, 27.3, the mere fact you've issued an application for summary judgment, I put my defence in, on the face of it,
Yes.
27.3 still applies.
Yes. And I suppose what the court would do if you applied for one is just list it to come on with the summary judgment hearing.
Yes. But if I hadn't filed my defence, then 27.3 cannot apply.
But all this presupposes everybody's read these rules to the letter, doesn't it?
Yeah.
Of course, you have to.
Lawyers' fault.
You have to assume.
Absolutely.
You have to assume that up to a point. But what you've also got to work out is what you do if they haven't.
Yes.
This is one of the problems which arose in relation to the rather different Order 17, Rule 11, isn't it?
That's right. But like, if I may say, 27.34 is a pretty red letter. I mean, everyone knows that. I accept that the subtleties of what is the position if a defence has been filed, but at the same time an application for summary judgment has been made. Does 27.3 apply? Well, the fact is the rules don't tell you in terms, but on the face of it, they seem to indicate that you've got to file a case management conference notice anyway, which of course may well be the same day. The court may well say, well, we'll fix it for the date of the return date.
And if you're right, you could turn up on the deferred application for summary judgment,
Yes.
brandishing Rule 27.3 and saying, sorry, chum, you're struck out.
Yes. Well, there may then be a case of saying, it all depends, but there may then be a case of saying, well, of course, you can come back in under the application.
You have to do all that there, do you?
Yes, but it may be fairly simple. I mean, but my lords, I submit, obviously one can always imagine extreme cases where it's not so easy as exactly how the rules are meant to work. I accept that, but our case is simple.
Yes. Can I just ask, your case is simple. You spent an hour and a half explaining it to us. Have you squared Mr. Maharaj? Is he going to have time?
Yes, only briefly, my lord.
Yes. Well, you've got to leave time for a reply.
Of course, yes. Well, my lords, I don't have that much more. I did want to say something about the estate management case and the point about the first case management.
Yes, of course. Yes, no, it's an interesting addition to the authorities. Yes.
My lords, the estate management case
tab 8 and 24.
relevant judgment.
Yeah.
page is Mr. Justice of Appeal Jamadar's. Tab 23 or 24, I think. 24.
Yeah.
Pretty sure it's Jamadar in this, isn't it?
Yes. No.
Yeah,
Oh,
Jeremy.
no, it's not.
MS 2112 is the passage my learned friend took you to first.
Yeah, and then we shot on to a little later, yeah. 2116.
Yes. So 21.2 is where as where discussion begins. There's nothing in this part of the discussion to suggest that there can be what you might call a case management conference that takes place before the first case management conference. You then go to paras 20 to 22. And in my submission, it is plain that what Mr. Justice of Appeal Jamadar is saying in 20 and to 22 about the case management conference. This is page 2117. And that is, it has to be, the phrase is used, para 20, specifically scheduled. First sentence, case management conference is therefore a court hearing specifically scheduled for the purpose of exercising and so forth. I rely obviously on specifically scheduled. Then he goes on to discuss the position of a case that is not specifically scheduled for active judicial case management. Nonetheless, judge exercises case management powers. Such a hearing would, from a common sense point of view, also be, if only in part. Now, my lords, that I submit is equivocal. He's obviously holding back from saying it's a full-blown case management conference for all purposes of the rules.
Well, wait a minute.
Why not? Maybe he's just saying it'll do other things, but also, in part, it will be a case management conference.
Well, my lady...
Because
Yes.
it's by
Yes.
definition, that's the territory he's in. It's there for some other reason.
Well, in my submission, it is qualified from a common sense point of view, also be, if only in part, a case management conference. Then he goes on to say it's the substance of what occurs that matters. And I would accept, of course, in one sense, there can be a case management conference, not in the strict sense of the phrase, but there can be case management directions given. But in my submission, that is not, properly speaking, the type of case management conference envisaged by 27.3 or the other rules.
Well, I think you've got to start with 18, haven't you? Because that's where he poses the question, what is a case management
Yes.
conference? Says the answer is part 25, that is to say a CMC is a court hearing,
Yes.
needn't be an actual face-to-face hearing, but which is active management by carrying out any of the 13 actions listed in 25.1 and or any of the 22 listed in 26.1, makes orders, all of which are not exhaustive of the actions can be taken. So that he's saying that a case management conference is any hearing where that is done, but it's not the first case management conference, apparently.
No. Well, in my submission, that isn't what he's saying. It contradicts entirely the notion that a case management conference has to be specifically scheduled, but it goes further because he repeats this phrase.
It doesn't say, Mr. Knox. He's, at least one reading of 20.
Yes.
A case management hearing is one which is specifically scheduled and also other things.
Well, but it has to be for the purpose of exercising active judicial case management conference.
Yes.
And that you
Active
get from
case
21.
management powers. So any of the powers, even if it's not identified as a CMC.
The difficulty is you deprive the word specifically scheduled as such of any real meaning.
Well, yes, that's exactly what he's doing. Well, no, you're not depriving it of meaning, because you can have a hearing which is scheduled to be a case management conference. But at least it's at least a possible reading of 20 that he's saying, look, you can it's one which is specifically scheduled. Next sentence, it's possible that a hearing not specifically scheduled, a judge may actively exercise case management. Third sentence, that would also be in part.
Well, my lords, if he is saying what my learned friend wants him to say, I submit he's simply wrong.
Yes, that I understand.
And paragraph 21, I do submit one has to read this together with 21, 22 and 23. What Mr. Justice of Appeal Jamadar is undoubtedly distinguishing is between the first case management conference where he says which has to be specifically scheduled for the purpose of active exercising active judicial management. That's 21. And then he goes on at the end of 21, this is to be distinguished from an occasion when, at a hearing of proceedings not specifically scheduled for active judicial case management conference, a CPR judge for the first time actively exercises any such case management powers.
Well, that's fair enough. So there are two types. I mean, on the view against you, case management conference is something you can be specifically scheduled as such, or alternatively, it's something which has happened at which powers are exercised.
Well, you get the same point from 22 and 23.
But the first case management conference has to be specifically scheduled.
Yes.
Yeah. Well,
In my submission, that ties in exactly with the requirement for giving notice that a hearing is going to be a case management conference. So you know, when you turn up, it is going to be a case management conference.
yeah.
It may help to understand this judgment to bear in mind what the issue was,
Yes.
which is not when it started,
When
but when it ended.
Yes.
That's paragraph 3. And I anticipate he may be saying, well, after the first one, any subsequent meeting of the parties at which there is active case management may be
A case management.
it may be a continuation of the first one, or the first one may have ended. It may be a second or a third one, as he later says in paragraphs. Well, he starts with when does it end in paragraph 25. And
Yes.
he gets to that concept in paragraph 26.
Yes.
Yes, I think he's saying that even a scheduled first case management conference is not in fact a first case management conference unless
There's some management.
something happens there.
Yeah.
Yes, exactly. Some active judicial management is given.
So
Rather than I'm adjourning this on.
what do the other members of the court say on this point? Do they agree or disagree?
They don't say anything at this point. I think Mr. Justice Barrot agrees. They all agree on the result. But in my submission, the first point to note is it's strictly obiter. There's no question of this being what you might call a necessary part of his decision, at least in the way my little friend intends for.
What about, Madam Justice Jones appears, on one view, to have gone in a slightly different direction, doesn't she, from the present case, if you look at 2146.
In our case.
Yes.
No, in this case,
Yes, no.
from the present case.
Yes.
Yeah. If you look at 2146, at 43, isn't she slightly watering down the mandatory nature of a case management conference by saying the only orders that seem to be made mandatory by the rule are the requirement that a pre-trial conference be fixed unless the judge determines it's not needed, trial date or trial window be given, and the date for issue of the listing questionnaire. In some instances, however, even seemingly mandatory orders may not be necessary. For example, it's obvious that a matter settled at the first hearing would not require a trial date or trial window.
Well,
Is that a watering down at all?
in my submission, no. I mean, she's not on this point of what is a case management conference.
I see.
She's talking about 27.6, which is about orders for disclosure and so forth.
Yes.
But my lords, can I also ask, just, I'm conscious of time, page 2122, paras 37 and 38. Rather, 2121, paras 36 to 38. Mr. Justice of Appeal Jaminar makes it quite plain that the first case management conference, at least, has to be specifically scheduled as such.
Right.
Now, my learned friend says, well, what the rules might be envisaging is that there's such a thing as a case management conference which takes place before the first case management conference. And in my submission, that's plainly wrong. First, I say it is inconceivable that the draftsman would use a phrase such as the first case management conference, where what he was envisaging was that actually a case management conference could take place before the first case management conference. And it's a bizarre way of drafting things. The notion of first case management conference necessarily carries with it, this is the first time the court is holding a case management conference. Second, I submit that the rules proceed on the premise that the first case management conference is indeed the first time the parties attend the court for what is properly so called a case management conference. And if I can just ask you to compare go back to 18.4. Page 1719.
Thank you.
18.41 and 3, which deals with the first case management conference about joining in new parties. Now that specifically refers to the phrase first case management conference. When you go to 19.27, which is also about introducing new parties, and obviously has to be read together with 18.4, page 1726, the phrase first case management conference isn't used. And I submit that's obviously because it is taken as read that the first case management conference is indeed just that. There's no such thing as a pre-first case management.
Sorry, I haven't got which of the rules you're actually...
Sorry, forgive me. It's a comparison of page 1719, rule 18.41 to 3, which is joining the new parties.
18...
Well, it's making a new claim.
And 5.
Ancillary claim.
Yeah, 1, 3, yeah.
18.41 to 5, basically, about
Yeah.
bringing in new parties. You can do what you like beforehand, before the first case management conference, and 5, saying what you can't do after the first case management conference. Compare that with 19.2, 6 and 7. Where the phrase first is dropped, but it's obviously talking about the same type of subject matter.
Yeah.
And it's presupposed that, of course, the first case management conference is just that. And you have a similar contrast between the amendment provisions and 20.1, 1 to 3, which I showed you earlier. No amendments after the first case management conference, and 10.63, which was about being allowed to change your case, which doesn't refer to first case management conference, it's just case management conference. And one asked rhetorically, if my learned friend's submission is right about first case management conference, when is a court supposed to fix a trial date under 27.6? At the pre-first case management conference or at the first case management conference? Now, on my learned friend's case, presumably it's supposed to do that at the pre-first case management conference, which could well be before the defences are filed. So, in my submission, it makes no sense to say, as were this concept of a case management conference taking place before the first case management conference makes no sense.
Right.
My Lords, we refer, I don't think I need to address you on overriding objective and so forth. I've dealt with the point about there being no purpose in these proceedings. There was a purpose other than the interim relief. And I think, my Lords, the only other point is actively managing. We say, let's say for the sake of example, there is a case management conference whenever a court is actively, quote, actively managing a case. We say it wasn't actively managing a case here. It was just reacting to requests for adjournments. And it wasn't doing any of the things we'd expect a court to do at a case management conference. It's just saying, I'll give you more time, chaps. That's all right?
I think you said that already.
Yeah, that's it, my Lords.
Thank you. Yes, Mr. Strang? Yes, Mr. Maharaj.
My Lords, I'm aware of the constraints of time.
Well, let's just ask Mr. Brindle, how long do you need?
20 minutes.
Well, we'll have to be, I'm afraid...
15, I could if I...
We'll certainly allow you that.
I'll be glad if I can get 10 minutes, my Lord.
Well, your side has considerably overrun.
Yes.
I mean, you indented for an hour and a half. Mr. Brindle was less than an hour. So, without wishing to deprive us of the complete pleasure...
I can do better.
I can take 5 minutes, my Lord.
Well, I think 5 minutes
Okay,
would be
well.
very helpful. I'm sorry, since normally as a guest you would be very welcome, but you obviously divided it up between yourselves.
What I'll try to do, what I'll do, my Lord, I'll just refer to the references and the paragraphs.
Yes.
My Lord and my Lady, at paragraph 8 of our written case, we gave the three main components of our case. I wish to deal with the second component. The first component dealt with the plain and unambiguous terms of 27.3. The second component dealt with the important function of the CMC as distinct from general case management,
Yes.
and its purpose in the context of the litigation culture in Trinidad and Tobago. And that is what I propose to deal with in the 5 minutes, my lord.
Right.
My lord, at paragraph 7 of our written case, we made the point that an interpretation of Rule 27.3 that acknowledges the distinct function of the case management conference in the CPR is consistent with the purpose of Rule 27.3 viewed in the context of the litigation culture in Trinidad and Tobago at the time the CPR was implemented, which was by deliberate design, separate and apart from the civil litigation practices in England and Wales. My lord, in the case of the Queen and Secretary of State for the Environment and ex parte Spat Holm, your lordships would have, I'll just give you the reference, tab 14, MS 1982, at page 397,
Yes.
supports the principle that the context had to be taken into consideration, the context of the rules. And in the case of Bernard and C. Ballack, the Privy Council, in that case, made specific mention at paragraph 31. It's at MS 1845, tab 6, and Sir John Dyson stated, in interpreting part 21.3 of the CPR, the board has had regard to the litigation context in which the Rules Committee drafted the CPR. So it is in that context, in my respectful submission, it is shown that case management in Trinidad and Tobago is very different to what we have in England and
Yes.
Wales and in some other countries.
Right.
And your lordships and ladyship would see that in the case of Trincan Oil and Chris Martin, which is MS 2059, tab 19 at paragraph 15, Justice of Appeal Jamada made the point that when the CPR was being drafted, the English rules were in existence. And therefore, he was making the point that it is very different and it had to do with the litigation culture in Trinidad and Tobago. And if your lordships look at the case of the Attorney General of Trinidad and Tobago and Regis, MS 1805, tab 4, at paragraph 32, that point is also made.
Well, we've got that very helpful
Yes.
in your case. Yes.
Yes, my lord. And there is, so the Rules Committee sought to achieve this by shifting responsibility for the management of litigation from the parties to the court, and that is important of the case management conference. The courts would ensure compliance with procedures and timetables, and there would be established procedures. So the case management conference represents in the CPR the practical and philosophical expression of court control. And if I may quickly just ask your lord, well, I asked the board to look at the forward to the CPR and what Chief Justice Sharma said, and quite apart from at page 1691, to look also at page 1693. And our submission is that the case management conference is really the key to the CPR in enforcing court control.
Yeah.
So this distinction between case management conference and general case management is central to the reasoning of the majority of the Court of Appeal. And in our respectful submission, there is another case in the record, the case of Holder and the Attorney General, and that is at MS 2011, tab 16. It's a High Court judgment in Trinidad and Tobago, which construed 27.3 in the same way we have been advancing for it to be construed. And I'll give your lordship the reference. There's there's a good exchange between learned senior counsel for the appellant and Justice of Appeal Narayan at MS 1509 and 1510, in which Justice of Appeal Narayan said why he did not consider the precedent which was being advanced by the appellant to be in accordance with the CPR.
Sorry, 1509 to 10, where is
1509 to 1510. I can point out.
where do we find that? 1509 to 10, I'm not sure. Is that electronic?
That's the electronic number.
That's in the supplemental?
That's in this, that's in the present case.
Yes.
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 It's in the
transcript of the
supplemental.
present case,
Supplemental. The case of Hula and the Attorney General, MS 2011, tab 16.
Yes.
It is for that reason that we consider that this litigation culture in Trinidad and Tobago, which had to be redressed by the CPR, is very important in interpreting the function of the CPR in this case. I'm sorry, the function of the case management conference in this case.
So this is a discussion between Justice of Appeal Narayan and counsel, maybe.
Worth looking at the top of the next page.
Yeah. Right.
What Justice of Appeal Narayan said, he didn't consider precedent should be set whereby the regime in Rule 27.3 did not have to be followed, where a judge was seized of an application for interim relief. He said he couldn't buy that. In effect, that's what he said.
Yeah. Right.
Much obliged, my lord and my lady.
Well, thank you very much indeed. Yes, Mr. Brindle.
My Lord, firstly, just to try to clarify a point that my Lord Briggs asked about Part 8 proceedings.
Yes.
Like. The best I've been able to get with the assistance of Mr. Mutu here is that there is no separate CPR part for arbitration proceedings. There is something like our Part 8, which allows fixed date claims where an enactment requires a particular application to be done in that way.
Where the enactment requires it done by motion or originating application,
Yeah, exactly.
which I suppose the Arbitration Act doesn't.
No. The Part 62.2, which is the relevant fixed date claim procedure, could cover applications under the Arbitration Act for freezing orders potentially, although it's not mandated. But it couldn't cover the mortgage relief which is sought in this case, which could not be done under that procedure.
Yeah.
I'm sorry, my Lord, that's not very clear, but it's the best I've been able to do. Can I then come to Mr. Knox's submissions? And I think I can run it down into 4 points. The first point is what he says about Part 25 of the CPR and active case management. And with respect, he cannot be right when he suggests that merely assisting or responding to the parties who want to try and settle and therefore are seeking an adjournment is not within this. Could I just very quickly ask you to go back to Part 25 just to remind yourself how wide it is. Part 25(1). This is the definition of active management. The word actively is there right at the beginning. So all of these are active. None of these things listed are passive. And one of those is E, actively encouraging and assisting parties to settle the whole or part of their case. And I suggest that that would include assisting, and if the parties receive a request saying, please can we have time so that we can attempt to settle?
Yeah.
And the court says, yes, you can,
yes,
having addressed its mind to it, that must be active case management.
Right.
And you'll remember the form of the document we sent some time on, I won't go back to it, at MS page number 139, the letter of the 17th of May, sorry, not that one, the earlier one, 135, the letter of the 7th of March. The judge did actually say, please be informed that upon receipt of the letter from the claimants requesting the matter scheduled to be adjourned to facilitate efforts to have the matter resolved, the matter is indeed vacated. So we say there's absolutely nothing in the point that there's no active case management here. And picking up the second point of my 4 points, going back to the point I debated with Lord Mance earlier on, there is no basis for denying the judge's own finding that she was herself exercising active case management at a time before the strikeout deadline arose. And that is enough for my case. Dealing then with what my learned friends...
That's enough, what, on the basis of Justice Jamadar's definition of case?
No, not even, well, yes, partly that, but on the basis that if there is some case management actually being conducted by the judge, that takes it out of 27.3. 27.3 is not concerned with a case where the judge has already taken on the process of active case management. That does not depend in my submission, although perhaps I didn't put it quite as clearly as I should have done in the opening. That does not depend on designating it as a case management conference or giving it that sobriquet. It doesn't have to have it. It is true that most of my submissions are based on the further fact, and I don't resile from it in any way, of the fixing of a date at which case management directions could be given. And that is more obviously the Jamadar point, and the point that I want to say a little bit more about. Now, my learned friend has spent a great deal of time and has succeeded in some extent in showing that where one has a designated, proper, formal, I don't know quite what the right word is, I've played with the 3 words in my own mind, but I think the best word is designated, case management conference. There are many consequences to that, and the parties need to know where they stand. My case does not depend upon designating this hearing that was due to take place in 1st of March, then April, then May, as actually being a case management conference. So I have 2 strands for saying that. One is the wording Jamadar uses, and the other is 17.7. Can I deal with 17.7 first? Because with respect to my learned friend, I have to submit he hasn't really dealt with 17.7. We go back to that. This is highly relevant because it's actually specifically concerned with what happens on an interim application. And it's at MS page number 1717, I went to it. It is important to remember exactly what this says. It says, on hearing any application under this part, as that plainly applies, the court may exercise any of its case management powers under 26 and 27. It doesn't say may designate the hearing a CMC or treat it as a CMC at all. It says it may exercise powers under those rules and may in particular give directions for an early trial of the claim or any part of the claim. So the court can do all that without designating that hearing as a case management conference. And if it does that, the question then is, what is the effect of that when read against 27.3 and the automatic strikeout? So you have this hearing, the judge, which is what she actually did in the end anyway, hears the matter, gives her judgment. She doesn't say this is a case management conference at all. She says, I'm exercising powers under 26 and 27, and she's actively case managing the case, plainly in my submission. The simple question for this court is that or is that not enough to take it out of 27.3? Of course, as a matter of literal words of 27.3, you can't find any exception actually there stated. But that is the question for this court to construe according to the arguments you've now fully heard, and I don't think can be added to very much. But the point I wanted to make clear, because I suspect maybe I erred once or twice when I was on my feet before, this does not depend on it actually calling it a case management conference. It certainly wasn't called one.
When
So it
you
doesn't
say
require
it,
time.
by it you mean the 7th of March and the later?
Yes, and all the later
Yes.
ones.
Yeah.
Now, I get to the same position through a slightly more complicated route, through the Jamadar judgment. If I go back to that, but again, finally, we concentrate on some limited paragraphs. This is at tab 24. Now, reading it in a sense back to front, starting with 21 and 22, I don't think there's really anything between my learned friend and I anymore on any of this. He talks about specifically scheduled CMCs. And if you have a specifically scheduled CMC, then all sorts of things follow from that, which my learned friend has explained. It's true that this comes under a heading, when does the first CMC conference start? Because the particular rule he's construing is Rule 20, which has that word first in it, actually there. But much of this same analysis would apply to any other specifically scheduled case management conference. You need to know what is a specifically scheduled case management conference, which includes a first one, or may include another one. Now, I then go back to the crucial paragraphs, which I'll end with paragraph 20, which the court's already looked at quite enough. And the distinction between the first and the second sentences is by now, I hope, very clear. But in the third sentence, it's important to note, and again, perhaps in some clarification of my earlier submission, that it's only from a common sense point of view that the hearing that he is envisaging is a case management conference. It's not a specifically designated one. It doesn't carry with it the consequences that Mr. Knox has spelt out at some length. But it is, in a common sense point of view, a case management conference, because that's what it is as a matter of substance, not form. Now, I don't need, and this is perhaps my crucial point, in my submission, I do not need to carry with this hearing other consequences of being a case management conference. Indeed, if I do, I get into difficulties. I don't teach it. All I say is, it's 27.3. Here is this rule, automatic strikeout. Does that or does that not apply if you've got a hearing, like a 17.7 hearing, which is fixed, at which these case management directions, these type of orders are going to be made? Because if that is right, then that is good enough for my argument.
So a hearing in which case management powers are exercised, in fact, is outside
Yes.
27.
You can call it a de facto case management conference, but it's no more than that.
It takes you
Certainly not-
outside the scheme of 27.3.
Yes, takes it outside. And if I'm wrong, I will return finally, although my Lord Briggs wasn't terribly happy with it at the time, but I'll have another go at it. In my submission, my own friend's not dealt with my parallel tracks argument satisfactorily. Can I go back to it and perhaps come up with a slightly more likely scenario? You recall the parallel tracks argument assumes that the court actually goes ahead and gives some case management directions, perhaps in ignorance of the fact that the automatic strikeout date has passed. Now that might be, in the case I was putting, that the time had passed. Another possibility is that the time hasn't quite yet passed, but is about to pass. Imagine that the court were to give directions. The automatic strikeout hasn't yet happened. And then a week later, the time runs out. What is the effect of that? And you asked, several members of the court asked Mr. Knox about that. What happens is the whole case just disappear, as everything go, disappear up in a puff of smoke. Have all these case management directions been a waste of time? The answer is that there must be something wrong with the analysis if it achieves that result, in my submission. And that is why one is compelled, coming back to what is the absolutely central point, to read 27.3 so that it does not effect an automatic strikeout where, on this way of putting the case, there is a date fixed where there will be, or likely to be, case management directions given the whole rule, the underlying basis for the rule is satisfied because it's all about delay. There's no delay. Everybody's getting on with everything. And that it is quite possible to read the rule as not applying in that case. And then, ultimately, I have my other way of putting it, based on the fact that, in fact, there have already been case management directions given, and that itself is also, as another way of putting the case, sufficient. Otherwise, I think anything else would be repetition.
Well, the board's grateful to council for their submissions and will take time in the usual way to consider its judgment, which we handed down in due course. Before adjourning, I think the members of the board would like to note that we understand that this is Mr. Brindle QC's last case as a silk, and to wish him well in a future practice after a distinguished career here at the bar and considerable public service as well. Wish him well in parts of the world which we understand will include the Middle East and the Far East. Thank you very much indeed.